before he makes more statements.
And I did record the call.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements.
Here's where this hearing takes a serious turn. The court isn't dealing with a simple disagreement between a defendant and his attorney anymore. There's now an alleged recorded conversation involving an exchange of testimony between two separate cases. That distinction matters because witness interference can carry consequences far beyond the original case. And notice the judge's approach. Before making a final decision, the court wants the defense to hear the evidence and respond. That's due process in action. But the question hanging over the courtroom is huge. What exactly does that recording prove?
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because he's interfered.
Doing the training about the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes.
Okay, could you please state your name?
Thoroughly.
What was that noise?
Shouldn't you check? I don't feel safe. Why are you just pointing? What?
Don't stop at some.
It'll stop at some point.
I feel very safe.
Wow, I know. He's like, you are all over it. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange of a pending case where Mr. Quasny is the defendant of an AMV against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want to document the potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge. I indicated to, what's her name?
Mary Rubio, Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Kwasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he...
I don't know. Are you a lawyer?
I was...
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorneys. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the call.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea. Not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Kwasny agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to.
And there it is. The judge has heard enough to make an immediate preliminary move. The bond is now in serious jeopardy. Why? Because bond conditions aren't simply about showing up to court. They can also restrict contact with witnesses and conduct that could interfere with the integrity of the proceedings. The judge is clearly signaling that this alleged communication could be viewed as a violation. But importantly, the judge still wants the actual recording heard before locking in the final decision. Evidence first, punishment second.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, right? Has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you. Somebody needs to listen to him.
Yes.
Just listen to it.
Have you heard him? Or,
Just now. Oscar and I listened to it together.
okay. All right. I'll recall that momentarily.
And then everyone else gets folded.
Everybody else is holding. And
Mr. Kennedy. Online has one from his children. I think it's Mr.
far.
Yeah.
Okay.
Yeah.
So this one we're going last. Right, no,
No. This one.
that's
Yes,
fine.
last.
So just hold down. Then it's between these two. What happened to yours?
That was at 2:00. We haven't gotten there yet.
Oh,
I haven't talked to you about those at all yet.
ow. Okay. All right, but this one has one. And then we gotta bring Lee back out. So, who's on this one?
This is four witnesses with Miss Tanha and I believe Miss Ackerley.
Okay. So, then this is good night.
9 is Burkett.
How many witnesses on that? One witness? Okay. Get Mr. Burkett in here. We'll handle that one. I'm gonna take a brief break. We'll handle that one, then I'll get Mr. Lee out. Okay,
Thank you, Your Honor.
I'm gonna deal with Lee.
That's my order then.
All right, Court Statement, Larry Lee. All right.
Good afternoon, Your Honor. Marie Tenha, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry?
Oh, there you
Good
go.
afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Rubble sent me, as well as Mr. Burgess, and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Rubble, who's the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Rubble has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort, and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it, so that the court is aware of what's going on in the matter where I represent Mr. Quasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
Now, the legal argument gets razor sharp. Both sides are fighting over the label. Was this a legitimate attempt to explore a plea arrangement, or was it an improper effort to influence testimony? Those are very different things. A normal plea negotiation involves the prosecution and defense negotiating the resolution of a criminal charge. What the prosecution is describing here is something else entirely. A proposed exchange involving whether witnesses testify. That's why the judge keeps coming back to the recording instead of relying solely on competing characterizations from the attorneys. In court, what people call something matters far less than what the evidence actually shows.
It would have been unethical for Mr. Burgess to call to try to say my client won't testify in this other matter.
of course.
If that, right? That's
Well-
what Mr. Burgess may not have done.
And that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that, but I just wanted
Your Honor,
to
if I
make
may.
the record. What, can I just finish though?
Let her finish.
Mr. Lee indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. The call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Did Mr. Burgess call you to try to, see if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo's had some trouble with the
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo's making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Crosby, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Crosby not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in the early stages. This needs to go to law enforcement. It has gone to law enforcement now, and we can follow up.
Mr. Arabo.
Your Honor, as you know, I'm a defense attorney. I think Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what he's being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how this slipped between the cracks, because in over 10 years of practicing, I've never seen something like this, where a victim turns into a defendant during a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he could one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Kwasny so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Kwasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Kwasny using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this. And it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listen
can
to
you
it already.
Can somebody send it to Ms. Weidling, and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and sort of listen to the call. I give my decision.
You have to go back.
To you. I'll handle that coming back out. So. I think Miss Ackerman's on that. So bring me that. Court's going to stay in recess. Everybody can remain seated. Bring. Then I got this here. Now I got Kennedy Brown. And got it. Yeah. Okay. Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tanhouse, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Get your name, please.
Clearly.
Okay. The issue is in this case that, first of all, we're adjourning the hearing over.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the, I'm on the bench, but I'm not doing these.
Okay.
So.
This is the moment the entire hearing pivots. The judge has now personally listened to the recording and is no longer evaluating secondhand descriptions. The court describes what heard as a clear quid pro quo. Essentially, don't testify if I don't testify. And that alleged exchange is critical because the judge is evaluating not just the defendant's words, but whether those words amount to conduct prohibited by his bond conditions. The defense can argue intent and context, but once the judge believes the recording speaks for itself, the room gets very quiet very quickly.
Set his preliminary examination July to defendant's request, so my next date is July 22nd, 2025, and that's another 12 p.m. start, because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over-exaggeration or an under-exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think there, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr. Lee has told
And
me.
I understand that.
And Mr. Lee
I
is
think
about jumping out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court, and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, and I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr. You might as well stop right now.
I have the text.
Because no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Take you.
Thank you, Your Honor.
Yeah. Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record?
Pardon? I am.
Are you still on the record? You know, I'm not sure who this kid is or what he's capable of or what sort of messages he can get out to other people. But if the court could put a no contact order because somehow I've become a witness in this matter, I'd appreciate that.
A no contact with you?
Yep. I don't want to be contacted by any third parties. I want out of this thing and I want to be done with it. Didn't ask to be here.
I will add that no contact provision.
Yeah, one of those, Your Honor.
But counsel, why don't you let us know how you really feel? All right. We'll take care of that.
I think the courtroom's been through enough today. Thank you.
Court does call the case of People versus Thomas Styron.
On behalf of the
Assistant Public Defender Otatella on behalf of Mr. Thomas Styron, who's to my right.
Sergeant out.
Sir, if you please come forward and be sworn.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give and be the truth and the whole truth tonight. Yes, sir. Take a first and last name.
All right, you may inquire.
Thank you. And preliminarily, Your Honor, for the record, at the first preliminary exam, the prosecutor at the time put on the record that the people intend to amend the complaint and information to add an added count 4 of felonious assault with the victim being Sergeant Hauk, an added count 5 of felony firearm, and an added count 6 of felony firearm. And
So 2 counts of felony fire.
yes,
All right.
and count 4 of assault with a dangerous weapon with the victim being Sergeant Hauk.
You said count 4?
Yeah.
You meant the 4th added? Or
Sorry. So we have 3 on the complaint, an added count 4 of felonious assault,
oh,
count 5 felony firearm, count 6 felony firearm.
okay.
Thank you. And then the basis would be count 5 felony firearm would attach to the count 4 felonious assault. Count 6 felony firearm will attach to both count 2 and count 1, the RNO and the fleeing.
Yeah.
Thank you, Your Honor.
All right.
Sergeant, where are you currently employed?
Sure.
For how long have you been employed as such? Were you working in your capacity as a sergeant with the Washtenaw County Sheriff's Office on January 31st, 2024?
Yes.
Were you working at approximately 12:06 a.m.?
Yes.
Is that your standard shift that you work is midnights?
Almost 6 p.
Thank you, PM, not AM, PM. Correct? So we're talking in the middle of the day. Thank you, my apologies. How did you come to be involved in this investigation?
Came in dispatch, rapid SOS, which is a geolocation for anyone hanging up on a call. And it was pinging in a particular location, so I went to check that space first.
Did you have the opportunity to go to the area where the 911 call was pinging from?
Yes, sir.
Now, when you are being dispatched to something called a geolocation or a 911 call pinging to an area, does that tell you something about the type of area that you're looking for?
It generally gives you intersections where it's closest to.
Specifically in this case, the intersections you were looking for, and let me ask this question a different way. What's the difference between, what is a rolling domestic?
They're in a vehicle, and they're moving in a vehicle, and there's a domestic assault taking place while they're in a car, while it's in motion.
Thank you. In this particular case, when you were dispatched to this area, were you looking for a rolling domestic?
Yes.
Why?
That was the call minutes.
Did you have the opportunity to make it all the way to the area that you were being dispatched to?
I did. I checked that area and I couldn't find anybody.
What did you do after you did not find anybody at that location?
On the dispatch screen, there was a name that I recognized from previous domestics. The female was involved as a victim.
That's the name you were familiar with.
Yeah.
When you are in this moment back in January 2024 and you are familiar with this particular victim, do you have a suspect in mind?
I had, after some research, a particular person that I know. This analysis that I got him from his cat.
Do you know the race of the person that you had in mind as the suspect?
Yeah.
And what was that race? White male. While you are looking around for somebody related to this rolling domestic, do you come across somebody otherwise?
I did, yes.
This other person that you come across, where are they?
So I did some research on the other corner of Tyler and called them. So I went to that location first and checked that. On the station there, I was doing some other research on the vehicles that were in the part of the address, and I was asking for all the vehicles that were registered to the particular female victim that I was looking for. So I could go look for those cars. They were out and about. And one of the cars was a vehicle with license plate on it. I passed my driver's side door with no license plate.
What did you do when you saw that?
I asked dispatch, the person I was speaking to on the lead channel, whether or not they could tell if the lien return for the vehicle plate was a sedan or a van. And I did not get a return from them. I didn't get a response from them, so I actually got stopped.
When you attempted to effectuate a traffic stop, what area were you located in?
I was on Calder. I was facing north.
Were you in the area of Calder and Seneca in Ypsilanti Township, Washtenaw County, Michigan? What is the speed? You were on Calder?
Yes, I'm Calder.
What is the speed limit in that location?
25 neighborhood.
When you say that you attempted to effectuate a traffic stop, what did you do to attempt to effectuate a traffic stop?
Lights initially. I was working to effect a traffic stop.
Fair to say that there was a traffic violation occurring of not having a plate on the vehicle.
Yes, sir.
And then in addition to that, you were looking for a suspect regarding this domestic violence situation.
Yes. Fast script of current boyfriend.
When you say the person in the vehicle, you're referring to the driver?
Yes.
Thank you. Once you your emergency lights, what occurred?
The vehicle did not stop.
What occurred? What did the vehicle do instead?
So I activated my siren.
Once you activated your siren, the vehicle kept going? Was there a point that the vehicle came to a stop?
It did turn into a driveway.
For how long did this pursuit continue before it turned into a driveway?
About 20 seconds or so. My license started activated.
Once the vehicle pulled into that driveway, what occurred?
Driveway. Brake lights came on the car. I could not see the driver's side of the vehicle at that time. The brake lights were on, which indicates to me that the driver was still seated in the car. And as I went to exit my car, the brake lights came off and the car shifted.
So fair to say, because now I'm understanding that you could not see the driver's side. So fair to say when the driver pulls into the driveway, he must be turning right into a driveway.
Yes, you are.
And you are behind his vehicle?
Off to the side. I didn't get completely behind him.
When he pulls into the driveway, do you remain on the road or do you pull in the driveway behind him?
I'm still on the roadway.
And so in this angle, we kind of have an L shape of vehicles.
Yes.
Fair? And you don't have a visual of the driver's side of the vehicle. Thank you. And you've described what you've observed about the brake lights. And then I believe you said you saw the vehicle shifting.
Yes, you can see the vehicle shift.
And what did that tell you?
Indicated with my training experience that somebody was exiting on that side of the car.
What did you do when you observed this? And coupled with the brake lights?
Yeah, coupled with that, not being able to see what they were doing, I pulled my fire out and kept it delivery.
Are you saying, are you exiting your vehicle while you do this?
Yes.
And are you saying anything?
Not until I see the person.
What do you say when you see the person?
Something to the effect that you put your hands in the car, put your hands in the car.
How are you uniformed during this time?
As I am here, stated in court, I've got one mark 360 degrees and shares of it.
When you tell the driver of the vehicle to put his hands on the car, where is your firearm?
Still at the low ready.
What does low ready mean? I apologize.
So it's not directly pointed at somebody, but it's slower. It's at the ready to be utilized if necessary.
Thank you.
Directly at them if I need to.
Am I understanding that both of your hands would have been on?
No, I could use I had at some points, yes, but sometimes no. I could use my hands to gesture.
I understand. Thank you. The person that got out of the vehicle from the driver's side, if you were to recognize them again, if you were to see them again, would you recognize them?
I would.
And is that person present in the courtroom today?
I would be assuming because he's wearing a mask, I can't.
I understand. Thank you. Your Honor, could you ask him is that appropriate?
He just did.
He has. Okay.
Yes, that would be Mr. Schneider.
Thank you. Thank you, Your Honor. Please let the record reflect that the witness has identified the defendant.
Without objection, record so reflect.
And so the defendant is the person that you are ordering to put his hands on the hood of the vehicle. When you are ordering him to put his hands on the driver's side of the van, have you walked around to the driver's side of the vehicle with him, or where are you?
I am coming around, so I was stuck on the blind side of the car, which means I couldn't see him. So as I'm coming around the nose of my car, I'm able to finally have him come into view, and he is outside the vehicle. That time at which time I ordered to put his hands on the side of his van.
And did he comply with that command? What did he do? Do you recall the things that he was saying to you?
Some of them.
Do you recall something along the lines of him being at his house?
Yes.
this indication of essentially he's at his house, so you no longer have authority over him?
Something along that line. Thank you for that.
Did he comply with your verbal commands?
No,
Did you did you give him any additional verbal commands of what you wanted him to do?
yes, in addition to telling him when I stopped him.
Fair to say that one of the things that you're repeating to him is to put his hands on the vehicle.
Yes,
And even while you're repeating it, he's refusing.
that's correct.
While he is refusing to comply with your commands, do you do anything with your firearm?
Holstering it and just kind of walk up and make an arrest.
What was he under arrest for?
Shocking.
Are you able to make it all the way to him and effectuate an arrest?
No.
Why not?
As I was approaching, he said, I'm armed. So I withdrew my firearm and pointed directly at him.
Why did you do that?
For my defense.
Once he indicated to you that he was armed, did you see a firearm prior to him being in your physical custody?
No.
Did he indicate to you where the firearm was? How did he indicate to you where his firearm was?
He gestured with his hands.
What does a gesture mean? Is he pointing or something? And where was he pointing?
Towards like his midsection area. He was wearing like a sweatshirt.
Did you have the opportunity to observe his hooded sweatshirt at that time?
If I could see it.
You could see it. What does that mean?
I could see the sweatshirt.
Was there anything about his sweatshirt that appeared consistent to you with being in possession of a firearm?
You could see that there was weight in the pocket. I just couldn't identify whether it was a firearm.
So after he's identified to you that he has a firearm in his possession, does he threaten you?
Make a threat, yes.
How did he threaten you?
While this, in the time frame of discussing whether or not he was armed with a firearm, he had indicated he was going to cook me.
So let's take that a step back. So what is the conversation that's going on about the firearm?
That he has it, he's armed with it.
What is his tone and demeanor while he's communicating with you?
He's argumentative. He's got does a blade stance, which is a defensive or combative stance. It's not someone who is complying with my orders, illegal orders to go and be placed under arrest.
And while he's in this argumentative tone telling you about his firearm, he says to you, I'm going to cook.
Twice.
He says it twice. How did that make you feel?
I thought he was going to shoot me.
What did you do while you were feeling that this armed person who was argumentative with you was going to attempt to shoot you? What did you physically do?
Well, I retreated a little bit. I put my vehicle engine lock between him and me. And then I started looking at the backdrop because I saw movement back there. Email and maybe some kids in the window or some moving in the window of the house. So I had to take into account all that stuff. Something like that's going to happen.
When you say that you're looking at the backdrop, is part of that for the event that a firearm is discharged?
Yes.
Either yours or his?
Correct.
Is there a point that he is explaining to you that he intends to defend himself?
Yes.
Is there a point that he says to you, do you understand me?
Yes.
Fair. Oh, thank you, Your Honor. The question, do you understand me? Did you understand that to be related to his statements about defending? While he is saying these things to you about defending himself and do you understand me, is his argumentative tone continuing?
Yes, it is.
Is there a point that you were able to place him under arrest?
Yeah, back up around the scene, we were able to give him a reply.
Backup arriving on scene, would that include other deputies?
Yes, multiple deputies.
Is there a point that he's in handcuffs? After he is in handcuffs, is a search incident to arrest conducted?
It is.
Do you know if a firearm was recovered?
Yes, I'm going to cover you first.
Fair to say that this was I'm going to give this a try here, a handgun?
Yes.
It was a Taurus, correct?
Yes, ma'am.
Do you recall whether the Taurus handgun was, whether it had any ammunition in it?
I believe I had a little magazine, but it was not around in the chamber.
Thank you. Now, some follow-up questions about what occurred after he was arrested. Did you transport him to the Washtenaw County Jail?
I did not.
Why not?
Well, I was on the way to Washtenaw County Jail. There was another incident that happened, and me being a sergeant, I had responsibilities to attend to those situations and emergencies, and I can't take a prisoner to those emergencies. This emergency was a vehicle to a house while undercover units from another police agency were chasing it, and that drew our resources plus myself. So I had to release independent charges.
So you had initially intended on transporting him to the Washtenaw County Jail?
Yes, sir.
There was a point that he was released from your vehicle?
Yes, he was.
And that was not for lack of probable cause to arrest?
No.
Thank you. Your Honor, may I have one moment?
You may.
Thank you. Your Honor, I have no further questions for this witness.
Cross-examination.
Thank you, Your Honor. Good afternoon, officer. Thank you for spending it with us. Officer, you had stated that you were on a different mission that day. Is that correct?
I guess I was on another call service at the time that I came across Mr. Starr.
All right. And you were looking for a white male that day?
I was looking for a white female with an animal.
Okay. And what brought you into contact with Mr. Styron?
When I got back, the other vehicles that registered to the female item, one of them was a Buick. I couldn't discern whether that Buick was a sedan or a van, and it didn't have a plate attached to it in the return. So when that vehicle came by, I had to look at the driver. And he slowly made the turn. And when he went by me, he looked like he was alone in the car, but I couldn't be certain. So I effectuated the traffic stop to do the investigation.
Okay. You didn't have a name for the other individual you were looking for?
There was a name. I just can't remember offhand. It was in the system related to the
Okay. Now, you stated that you approached, that you made a stop of Mr. Styron, is that correct?
Yes.
Okay. And you stated when you made the stop, you initially flicked on your lights?
Yes, turn my lights on.
Okay. And then, do you know approximately how long those lights were turned on?
I had to review the videotape to be certain.
Okay. Now, when you make stops, do you first turn your lights on?
Yes, lights come on first.
Okay. And then is there a brief pause before the sirens go on?
Generally speaking, yes. Depending on what we're doing, yeah.
Okay. Now, so lights go on, then sirens go on after. Is that correct? Okay. Now, do you do this so that if someone doesn't stop with the lights, then the sirens go off?
It's done for that reason, but also it's, you have to have the sirens and lights activated for the flip. So if you just have your lights on, it's not the same as if you have your lights and sirens activated. You want to give the person ample opportunity to go over.
So I want to go back for a second. You said that you turn this, you said you turn the sirens on, excuse me, you turn the lights on, and then you said something about the sirens go on for the fleeing and eluding?
The sirens go on because you want the person to pull over. But if you just have your lights on and the person keeps driving, it doesn't meet all the thresholds of that fleeing and eluding. So you need to have the siren activated. All your emergency equipment must be on.
So you were trying to meet the threshold for fleeing and eluding by turning on the sirens?
It's required.
Now, at this point, when we have Mr. Styron pulled over, okay, you state that you come out of the car and you have the pistol at the low and ready.
Yes.
Okay. Is that the first thing you do when you come out of the car? Do you have the pistol out right away?
In this particular instance, or are you referring to general?
In this particular instance.
In this particular instance, I did do the behavior of him, yes.
Okay. May I ask why that's the first thing we do?
Because of his behavior.
Okay. Now, what was his behavior up to this point?
Failed to stop in the exit of the car.
Now, is that the general policy?
It's not a general policy on that.
Oh, there's not a general policy on that.
That's police experience.
Okay, so is that your particular police experience in this? Okay, so what about Mr. Styron's behavior made it so that when you stopped him, you felt you had to pull the weapon out right away?
Because he continued to drive, and the sirens came on, and he continued to drive, and he pulled into a driveway. Then he exited the car after I exited my car.
Now, you stated that he continued to drive for about 20 seconds.
Yes.
And you felt that after he drove for 20 seconds and he exited the car, the first reaction should be to pull out your pistol.
Yes, I'm having it below ready to protect myself, 100%.
Okay. Now, during this whole incident, you wore a body cam, correct?
Yes.
Okay. And did it capture a video of the incident?
Yes.
Okay. It was activated during the incident, obviously.
Yes.
Okay. Now, if technology will allow me, I'm going to show you a clip of that incident for authentication purposes. And we'll ask you what it is.
Is this body camera? You ready?
Yes.
I'll just see ready. You don't.
Okay. You guys might have a stipulation, Your Honor. That's okay. Thank you.
Defense Exhibit A.
Thank you.
Sorry.
Required to my house. Don't put your hands on the car. For what? You're under arrest now. For what? You're under arrest now. Yes, bro. Don't put your hands on the car. Yes. Don't put your hands on the car. You just rolled down from here, which is the violation of the law, and you put your hand down your traffic stop. Can't do that. You know, listen to me. So there'll be more people coming and you'll be going to handcuffs. I'm going to handcuffs. For what? Huh? What was I doing that? This one? That's all I take. I would beat your ass, bro. You think so? I don't know. I'm supposed to take my firearm out. I can hold down now, get back to it. So we can do that route. I'll shoot you. You pull that back, you pull that pistol out, I'm gonna shoot you. You will not pull that down. You will not pull it down. You will not do that. You understand? You attack me. I will defend myself. If you don't stand, then you will contact me and come back. Somebody's trying to take me. You are under arrest at this point. You cannot leave. So, is it passing the firearm? And there's others vehicle and fuel with a black mask. Stop it. Stop going. Yeah, obstructing, get something in there. If I was away, if down this is bit, I can stop you, I can talk to you. You, and now the law. Yes, you will. You can.
For the record, sorry to interrupt here. And I'm going by the time marker on the Axon body camera. Defense started playing at 12:05 and 18 seconds, and we're now stopped at 12:08 and 36 seconds.
Thank you.
So, Officer Hoke, you had stated that you came out in the low and ready, correct? I'm sorry, I didn't hear.
Yes.
Yes, I apologize. And Officer Hoke, you had stated that the pistol was not pointed at Mr. Styron before he informed you that he was armed. Is that correct?
Ready. It's in his direction, but I hadn't leveled it completely at him yet. You've seen my level at him when I brought it completely up. The little ready, it's resting right here. It's resting right here. So it's not directly pointed at him, but it is pointing in his direction. There's a difference between low ready and pointing it directly at him.
So, Officer, do you believe that this was a de-escalation tactic?
This is me telling him exactly what he needs to do. So yes, this is a de-escalation tactic.
Officer, at any point, did Mr. Styron point a weapon at you?
No.
Okay. Officer, at any point, did you actually see a firearm on Mr. Styron?
No, sir.
Okay. Officer, when you were giving these commands to Mr. Styron, your pistol was out the entire time, wasn't it?
Yes.
From the onset of the stop throughout the entire incident, your pistol was out, was it not?
I believe there was a market there where it was either holstered or was almost holstered. Right? So I went to make contact with him before he was armed. I can't remember if one all the way in the holster, down my side, get ready to go into the holster before I make contact to make explosive arrest. When he said he was armed, I backed up and put one that, yeah.
Sir, isn't it possible that your pistol being out could have impacted his ability to follow these commands?
No.
I have no further questions, Your Honor.
Yes.
You indicated in one of your answers something about lights being on, and you use a siren because you want to give somebody every opportunity to stop.
Yes, they needed to pull over. Yeah.
Fair to say that that is what you did here. First, you attempted to use your lights. He didn't stop. Yes? And then you turned to your sirens as well to try to get him to stop.
Yes.
You didn't want to have a situation where he claimed he didn't see your lights.
Right.
Thank you. Pointing the gun at him. You're a sergeant, correct?
Yes.
Fair to say you have extensive training and experience on police officer safety.
Yes.
You are not required to wait until a defendant has you at gunpoint before you draw your weapon, correct?
That's correct.
And you are not required to wait until a defendant has fired at you, risking your life, until you point your gun at him, correct?
Correct.
Thank you. I have no further questions.
Anything else?
Just one further, Your Honor. Regarding the cook you. Okay. Now, we hear Mr. Styron say, "I'm going to cook you," correct?
Yes.
Okay. Does Mr. Styron go on further to say what "I'm going to cook you" means?
Yes, it did.
What did he say?
When I asked him to clarify, I asked him about the statement while we were having dialogue, and he said that he cooked me exactly, religiously, something to do with suing me. It was no problem suing me.
Thank you. No further questions.
Okay.
Thank you.
Keep
Just to
going
be
back.
clear, we listened to the recording of that while we watched your body camera, right?
Yes.
To be fair, what he says is, "I'm going to cook your..."
Your weapon is pointed downward.
Yes.
Is that correct?
Yes, sir.
And there is a clear point on the video after he tells you or informs you that he's armed, that you then bring it basically to the ready.
Yes. Yes, sir.
All right. Thank you. Anything else from either side?
Nothing for the people. Thank you.
Nothing further from defense. Thank you.
Sergeant, thank you.
Yes, sir.
Your Honor, people have no additional witnesses.
Any witnesses for the defense?
No witnesses from defense. Thank you kindly, Your Honor.
Motion.
Thank you, Your Honor. This time the people would motion to bind over on an amended information that added count 4 felonious assault, added count 5 felony firearm, added count 6 felony firearm. Thank you.
Your Honor, defense would move to dismiss the felonious assault. There was no indication that a weapon was pointed at the officer at any time. There was no imminent threat of a weapon being pointed at the officer. Leave the requirements.
There was no imminent threat? Say that last part again.
There was no imminent threat of a weapon being pointed at the officer.
Okay, go ahead.
We would move that be dismissed, Your Honor, as to believe that with the weapon being, with the officer's pistol, with the officer's pistol being present from the beginning of the stop to the entire incident throughout, my client, Mr. Styron, wasn't able to function properly in obeying the lawful commands. He was placed in a state of fear.
So you're saying the sergeant's command to put your hands on the vehicle, he couldn't follow because the officer's weapon was drawn? That almost seems counterintuitive to me.
Your Honor, the situation was escalated to a point that it didn't need to be at, Judge. It was an unreasonable use of force at that point.
Okay. going to vehemently disagree with you. And probably one of the reasons I'm not a police officer, because I don't know that I could have had the discipline that the sergeant did. But go ahead.
And with those two counts, Your Honor, the fleeing and the looting there was only 20 seconds of, let's see, at 23:50 in the video, the sirens go off. The lights turn on at 23:20, the sirens going off at 23:50. If he didn't see the lights for those 30 seconds, there's only 20 seconds of actual siren time. And I believe that is an adequate amount of time for someone to be pulling over, Judge. So if he stopped at that appropriate amount of time, 50 seconds total, Your Honor, would be a reasonable amount of time for someone to pull over. I don't believe there's enough to go on the fleeing and the looting. We would ask that that be dismissed. If those are dismissed, the felony firearms cannot follow. So for those reasons, we'd ask not to bind over. Thank you, Your Honor.
Thank you, Your Honor. So this is a situation where people don't understand that when the police stop you and the police are effectuating an arrest, it's not a mutual argument. You don't get to fight with the police. You don't get to pull your gun out. You are under arrest, and this sergeant is in control. And when Mr. Styron refused to turn over control to the sergeant, he committed felonies. So first, to say that 50 seconds is a reasonable amount of time, I mean, to pull over a vehicle, it takes seconds to pull over a vehicle. We can all, and Your Honor could take certainly judicial notice of your experience as a driver as well, that you can immediately pull over your vehicle, and that is not what happened here. However, if Mr. Styron had
What do you mean, that I've been pulled over?
No, just that people genuinely, yeah, you probably pulled a vehicle over at some point somewhere, but unrelated to the police. But Mr. Styron doesn't get out of his vehicle and say, "Oh my goodness, I'm so sorry, I didn't see your lights." He proceeds to argue with the police officer as if he has any leverage in this equal argument, which it's not. It's an arrest. The officer caused fear in Mr. Styron. Frankly, I hope that he did, because I hope that Mr. Styron realized how close he was to being shot given his actions. But what Mr. Styron was able to do was not freeze up in fear, not cry, not be so scared of the officer, but instead say, "I'm going to cook your ass, bro." Yell at the officer about how he is at his house. Yell at the officer about how he's not going to be put in cuffs. That's not somebody who's just frozen in fear. That's somebody that doesn't understand what the law is and doesn't understand that this sergeant is the person that was actually in control. Thank you, Your Honor.
Thank you. Judge Kelly, anything else?
Nothing further, Your Honor. I would emphasize on the felonious assault, though, there was no weapon pointed at the officer at the time. The officer was in control of the situation, Your Honor.
But hold it. To have your argument is that the weapon would have had to have been drawn or displayed to have the felonious assault?
Your Honor, the officer was in control of the situation. He had his weapon drawn, and Mr. Styron he's a CPL holder in this situation, Judge.
All right, that's fine.
He told him he had the gun on him.
Arguably, yes.
But it's at the very least, Judge, the felonious assault, I would be pushing a little harder on that one because the weapon was not drawn or pointed.
That's what I'm trying to figure out. You're indicating that the weapon would have to be drawn to have a felonious assault. When, if there were no weapon, but he threatened the officer and the officer had reason to believe that he could do that, then that would clearly, wouldn't you agree, be an assault?
I think there's an indication in this particular instance that he was in a position to do that, Your Honor. In this particular instance, the officer has control of everything that's going on. I think this is more of a situation of my client is in fear of what's happening and is rambling words and just spewing things.
Oh, no. He's not rambling. He is directing words at the sergeant in hopes of having a certain result happen. That's what he's doing. this isn't just some wild rambling. Go ahead with your argument. I'm sorry, I didn't mean to.
I know, I let it rest.
In this case, with regard to the pleading and alluding third degree, defense's argument of the timeline, I think what one needs to really pay attention to in the body cam footage is to figure it out. Because if you just say 20 seconds or 50 seconds, maybe that doesn't seem like a long time, depending on the speed at which you're traveling. If you just watch the vehicles or the houses that go past in the back of the video, you can see that Mr. Styron traveled quite a ways, and certainly could have pulled over within that time frame. It isn't like he just went 2 houses down. He is behind him for a long time, and Mr. Styron doesn't pull over. I think certainly that gives the court basis to find over on count 1. With regard to the police officer resisting and obstructing, I think the body cam is probably the greatest indication that he resisted and obstructed the officer. The officer told him, he continued to verbally fight with the officer regarding that, and so the people have sustained their burden. Count 3, the driving while license suspended, follows along as misdemeanor. Regarding the felonious assault, court does believe that a felonious assault occurred, which quite frankly is, in my estimation, why the sergeant had his weapon drawn. But at the time that he is giving commands to Mr. Styron is refusing to obey those commands, then informs the officer, and I would say not in the way I don't think that's contemplated by our laws regarding having a concealed weapon or CPL, but informs the officer that he is armed, then makes statements that at some point may have been clarified, but about cooking him and other things. All of those taken into account, this court believes, constitute an assault, because he is, in essence, reasonably making a threat. He has the ability to carry out that threat. The fact that that threat involves the use of a weapon, this court believes, with that analysis, there are other facts and circumstances that play in when you look at the body cam footage. The court believes that in and of itself could constitute a felonious assault in this case, and will bind the defendant over on the requested added count 4. That then, as to count 4, the court having found that, as to count 5, the felony firearm, the people have sustained their burden of that, as there is the firearm present, and also have sustained their burden as to count 6, the felony firearm. So the court would bind the defendant over to stand trial on counts 1, 2, 4, 5, 6, with 3 following.
Your Honor, for the record, count 4 is felonious assault.
Correct.
At 0.81.
Give me that again, I'm sorry.
750.82.
Correct.
A 4-year felony and for $2,000.
Right.
Count 5 and 6 are 750.227B.
7D.
B is in boy.
Okay.
Mandatory 2 years in prison, consecutive and preceding any other sentences.
Right.
Your Honor.
Kelly, do you waive presentation of the information?
Yes, Your Honor, we will.
And waive its reading.
And
Yes, Your Honor, we would waive the reading. We would stand.
defendant every way for a reading standing mute, the court will enter a not guilty plea as to all 6 charges. Pre-trial in this matter will be set for
November 18th at 1:30 before Judicial Slay Monday.
November 18th, 2024, 1:30, Slay Monday. Bond will continue. Thank you.